The next case I will be discussing is Mederi Inc. versus the City of Salem. In this case, the SJC is presented with an appeal by an aggrieved cannabis business license applicant against the City of Salem's denial of approval for a host community agreement. The case resolved longstanding questions about the role and responsibilities that municipalities play with respect to host community agreements needed by a cannabis business to obtain state licenses from the State Cannabis Control Commission. Now, since the sale and recreational use of cannabis became legal as a result of the passage of General Laws Chapter 94G, entities seeking to establish cannabis enterprise in their respective host communities have been wrangling through the statute adopted, along with regulations of the State Cannabis Control Commission, the state entity that regulates the sale of cannabis products in Massachusetts. In the case at hand, Mederi Inc. sued the City of Salem, contending that by rejecting Mederi as a host community partner, the city effectively precluded Mederi from being considered for a license to sell cannabis products, since an approved host community agreement was necessary for applying to the Commission for a license. Mederi also argued that the city's process was arbitrary and capricious and contrary to law. Mederi argued that General Laws Chapter 94G, Section 3, subparagraph D, requires municipalities to enter into a host community agreement with a prospective applicant if the applicant demonstrates that it is able to fulfill the requirements imposed for host community agreements. The Superior Court judge granted the city's motion to dismiss. Mederi then took an appeal. The Supreme Judicial Court took the matter up from appeal, directly bypassing the appeals court. Taking appeals directly from the trial court appears to be a recent pattern in these early cases interpreting the cannabis enabling statute. Now, in its decision, the SJC upheld the city's denial of the host community agreement. The SJC specifically noted that, quote, nothing in General Laws Chapter 94G, Section 3, imposes a duty on a city or town to enter into a host community agreement with a prospective recreational marijuana establishment, simply because that establishment is able to fulfill the municipality's host community requirements. Indeed, the SJC continued, General Laws Chapter 94G, Section 3D, the provision governing host community agreements, merely provides that a prospective marijuana establishment must enter into a host community agreement before it can operate. Next slide, please. The SJC noted that the statute actually contemplates a negotiation between the host community and the applicant, stating that the HCA must include all stipulations of responsibilities between the host community and the cannabis establishment. The SJC next reviewed Salem's host community agreement application process. Now, the city had passed an ordinance limiting the number of cannabis retail establishments within the city to 5. It published guidelines explaining all the procedures that a prospective applicant must follow, including provision of detailed information on the proposed operation of the businesses, as well as financial backing and business plans. Notably, the ordinance did not require the city to enter into an HCA with every applicant that met the city's HCA ordinance requirements. In fact, the ordinance articulated all of the criteria by which an applicant would be considered for an HCA and established a review committee for providing recommendations to the mayor, who would make the final determination on whether to enter into an HCA with a particular applicant. The SJC concluded the first challenge raised by Mederi by stating that a municipality may use its discretion in determining whether to enter an HCA with a prospective retail application. The Supreme Judicial Court next dealt with Mederi's certiorari claim, alleging that the actions of the city in choosing to enter host community agreements with our applicants was, quote, arbitrary and capricious and had created an unlawful pay-to-play scheme. Next slide, please. A certiorari claim provides for judicial review of decisions arising out of administrative proceedings. Where the SJC here is reviewing a decision involving the exercise of administrative decision-making, a decision will be upheld unless it is determined to be arbitrary or capricious. In making this review, the SJC reviewed the previously mentioned city ordinance, review criteria, and administrative efforts involved in selecting applicants for a host community agreement. It noted that the city had limited the number of host community agreements over the issue, and that the city had demonstrated a reasonably articulated review criteria and applied those in an appropriate manner. It concluded, therefore, that the city had demonstrated a rational basis for its recommendations and were not arbitrary and capricious. The SJC finally dispensed with Mederi's arguments contesting the manner by which impact fees were determined by stating that as Mederi was not issued a host community agreement, it had no standing to contest host community agreement requirements. Now, this case has been heralded by municipalities for providing clarity in affirming local control for municipalities to establish their own criteria for awarding host community agreements, as long as they clearly articulate their objectives and act reasonably in their review procedures. Now, as promised previously, I will now touch base quickly on two other cases that are not in the materials, but also involve local regulation of cannabis businesses. The two cases both involve the town of Mansfield and a cannabis business named ComCan Inc. In the first case, ComCan Inc. versus Town of Mansfield, which was decided by the state Supreme Judicial Court on August 30th, 2021, less than 2 weeks ago, the town had attempted to block a medical marijuana company from converting to retail marijuana use. In 2016, the town had given ComCan all the necessary approvals to construct a building for a medical marijuana dispensary. With the establishment of General Laws Chapter 94G in 2017, it legalized retail marijuana sales. The new law specifically exempted existing medical marijuana providers from any zoning regulations that would prevent their conversion to recreational sales uses. The land court ruled that ComCan was entitled to convert to retail sales. On appeal, the town argued that ComCan did not qualify for the conversion because the dispensary was not yet constructed and therefore could not be considered as engaged in marijuana sales. The SJC ultimately held that because ComCan had obtained all local approvals for the medical marijuana dispensary and obtained a special permit from the town zoning board, then it could be considered to be engaged in marijuana sales and thus eligible for conversion to retail sales. Now, the second related case, the SJC decided on August 30th, is West Street Associates versus Town of Mansfield. In that case, an abutter to ComCan challenged the town planning board's issuance of a special permit allowing ComCan to open the medical marijuana dispensary. In 2012, after the passage of state legislation allowing for medical marijuana dispensaries, Mansfield passed a bylaw in accordance with the 2012 statute requiring applicants seeking such a use to be a nonprofit entity. With the passage of legislation establishing Chapter 94G in 2017, the 2012 statute was abolished, including the requirement that medical marijuana dispensaries be nonprofit entities. The State Cannabis Control Commission promulgated new regulations consistent with General Laws Chapter 94G, and after the passage of 94G, ComCan converted from a nonprofit corporation to a for-profit corporation. The land court judge found no problem with the planning board's issuance of the special permit and found for ComCan. In the recent SJC decision, the SJC was asked to determine whether a previously enacted municipal bylaw that permits only nonprofit entities to operate medical marijuana dispensaries is preempted by a statutory provision specifically eliminating that restriction. The SJC found that it was, declaring that, quote, the legislature evinced its clear intent to allow for-profit entities to distribute medical marijuana. This legislative purpose cannot be achieved in the face of the town's bylaw on the same subject, unquote. Therefore, the SJC held for ComCam.